You're watching Beyond 100 Days with Nifemi Oguntoye. Let's begin with some updates from the Federal High Court sitting in Abuja that has now granted bail to the former governor of Kogi State, Yahaya Bello, in the sum of 500 million naira with two sureties and like sum. Justice Emeka Nwete had granted him bail after he pleaded not guilty to the 19-count charge of alleged money laundering to the tune of 80 billion naira brought against him by the Economic and Financial Crimes Commission. The EFCC is prosecuting Mr. Bello for allegedly conspiring with his nephew Ali Bello and others to convert 80.2 billion naira belonging to Kogi State for personal use. The anti-graft agency further alleged that between July 2021 and April 2022, Mr. Bello aided E-Traders International Limited in concealing over 3 billion naira in an Access Bank account. The money laundering charges were read to Mr. Bello, who pleaded not guilty to all of the counts. Recall that earlier this week, on Tuesday, the Federal Capital Territory High Court in Abuja denied Mr. Bello's bail application in a separate case involving 110 billion naira in fraud cases. The judge, Marin Aneni, denied Mr. Bello's bail application because it was premature and incompetent. She then adjourned to 29th January 2025 for the commencement of trial. He also pleaded not guilty to the charges and was remanded in the Kuje Correctional Center after he was denied bail. Let's talk to lawyer and rights advocate Tunji Abdul Hamid on the program this hour. Thank you for joining us on Beyond 100 Days. We've seen two different rulings in the outgoing week, one denying bail, another granting it. What's your take on this discrepancy and how it might impact the overall trajectory of these cases?
Good evening. Thank you for having me. Firstly, let me say that there is no any discrepancy. There is no anything like that. What happens is a normal procedure in our practice. You can bring an application for bail as many times as you want. Well, you have a grant to bring it. You have a reason to bring it. So when you bring one application and it's refused, and there's a need for you, and you have another, you have grants that can overweight the other former grants, you can bring another application. So bringing an application for bail and refusing it and granting thereafter is not abnormal in our system. So it's not something that there is no discrepancy in that application. It's a procedure. You know, when you file an application and it's refused by the court, you can go back and prepare another application. Especially in this one, it was refused not because of not on merit. It was refused because it was said to have been filed before it was arraigned or even arrested by the police. So that was the reason why it was granted. So it wasn't on the merit. It was just based on the incompetence of the application. So it's not an abnormality in our system.
Following Judge Anene's denial of bail due to premature and incompetent application, the former governor was initially set to spend about 50 nights in prison, including Christmas and New Year holidays, before his next hearing, I believe, in January. Does this latest ruling granting him bail today in another case changes that reality for him in any way?
You know another case, they filed a new application for bail. You know, when that former application was struck out, they now prepare a new application after being arraigned. So that one is no longer premature. They now file it, and then they ask for urgency. In other words, they ask for a date for it, and the date has been given to them. And that was why it was added and determined probably today. So it's not something that is untoward. Like I said, bail is at the discretion of the court. The court has the right to either grant or refuse.
I'm not sure you got my question, Mr. Abdul Hamid. There are two different cases here before two different courts. One before Justice Nwete, the other one before Justice Anene. In one case, it's an allegation of about 110 billion naira. This recent one has to do with corruption allegations of 80 billion naira. So I'm asking, in the first one, the ruling we had on Tuesday, the case was adjourned till later January, and the appeal for bail was struck out. Does this new one has any impact on the previous one? That's the question I was asking.
Well, if the fact and the charge are not the same, then we have two different cases now. That means he has been granted bail in one, and he has no bail in the other one. That means even if he's able to perfect this bail that was given to him today, he will still remain in custody because of that earlier one that has been refused. So I was thinking we are talking about the same charge. I don't know that this was another charge against him. So I'm so sorry about that. Like I said, so if this is a new charge and he has been granted bail, yes, that means he is on bail on this. But on the initial one, the earlier one that has not been granted, he cannot. He will still remain in custody till that is granted as well. But he can also bring another application. I will not be surprised if a new application is brought for that particular one and the date is fixed before the 29th of January that is fixed for.
As a rights advocate, do you foresee this case, or let's call them cases now, because there are two of them, setting a precedent for future corruption cases involving high-profile individuals when you consider that the EFCC made futile efforts earlier on to bring Mr. Bello to court to begin his prosecution?
I will not see it as a precedent because so many governors have been brought before the court. So many people who have been ministers, who have been governor, or former governor, or Jews of Kalu, so many of them. So this cannot be a precedent of such, as far as I'm concerned. This become so serious also. People got interested in this because of the attitude of the former governor of Kogi State by trying to evade coming to court. There's nothing new in this case.
I remember that the issue with former Governor N500M was quite dramatic, but it's hard to remember if there was a case where, you know, the accused had some issues attending the court and, you know, getting some other court orders, challenging the jurisdiction of the court before which the cases have been taken to.
There are so many of them that I can't remember now because this is more open because of the attitude of the man put up. There are so many situations whereby governors will be invited, they will not go, and then they will be sending their lawyers and some other things. And because his own drag a lot, and at the point he was trying to even do a kind of drama by going to EFCC and thereafter go back to his house. So those are the issues why it's like this. But at least he's now in court, and I think that he now realized that, look, I don't have to run. Let me come and face my ordeal and see how it comes out. So I would not be able to say now that whether or not he is facing a serious trial or not until I see the evidence before the court.
All eyes on this particular case, especially given the drama that ensued before going to court. Recall that the EFCC chairman had claimed on national television that he will see this to a conclusive end. But what measures can be taken now to ensure that the trial is conducted fairly and transparently and that justice is served regardless of the public status this trial has now assumed?
What will happen now is for the AFCC, who is taking Yahaya Bello to court, to prepare themselves very well. In other words, arm themselves with proper evidence, because in criminal matters, even in civil matters, the burden of proof is on the complainant in this instance criminal case. The burden is on the EFCC to establish their case against Yahaya Bello. They have to bring evidence before the court. It's not for him to come and start defending himself and say I didn't. They must have to establish their own case first for him to even have a chance to come and give any evidence before the court. So the burden on the AFCC is to ensure that they've done their own proper investigation, which I believe should have been done, because if you have not done any investigation, why are you going to court? So I believe they've done their proper investigation, and then the presentation of the investigation and the evidence before the court is also crucial. And that is why you cannot say why matter is before the court. You cannot determine how it will go, because a slip can affect your chance in a case. Our case is not about it's about who can present this case properly, not about who is saying the truth sometimes. It's not about the truth, it's about presentation of the facts before the court.
Lawyer and rights advocate Tunde Abdulhamid, thank you for talking to us. Thank you so much for joining us on the program this hour.
Thank you for having me. It's my pleasure to be with you. Thank you.
We'll take a break now. When we return,